you play in supporting your loved ones with their mental health issues. Now, the Mental Health Act recognises that carers can be given information to support the well-being and recovery of their loved ones. Before that, you would be aware that often carers were denied access to information on the basis that it was a breach of privacy. So the legislation seeks to balance the rights of carers to have information with the privacy rights of consumers. For you as carers, critical times will be when you want information, will be to be involved in care decisions when your loved one is admitted to a mental health facility and at the point of discharge and thereafter. So under the Mental Health Act, there are about 4 main ways that you can be involved in the care of your loved one, and I'm going to deal with each of these under a number of headings. And I should just also say that I'm happy to share this paper with you after this event. The 4 main ways are: you are to be given information about particular events that affect your loved one. You have the right to be involved during the course of an admission in a particular way. You are to be consulted by care providers in respect of a number of matters. And finally, you are entitled to attend and be involved in tribunal hearings. The first main way that carers are involved is by being given information by the treating team. Now, the starting point is that a consumer can allow you access to their private health information just like any other patient. If that permission is not granted, then care providers or the treating doctor must tell you about these events, and I'm going to go through each of them now. First, you must be told that your loved one has been detained in a mental health facility within 24 hours of that event occurring. Secondly, you must be notified if and when there's going to be a mental health inquiry. Now, a mental health inquiry is the first hearing that a person has after being detained in a mental health facility, and the tribunal at that hearing is to make a decision as to whether or not the consumer should be further detained based on particular legal criteria. Now, you're entitled to be advised about the mental health inquiry in writing, and in a particular format. There is a form that should be sent to you which sets out the possible outcomes of the hearing. So I'll come back to mental health inquiries at the end. Third, you must be told about any absences from the mental health facility without permission or any failure of the consumer to return from leave. Fourth, you must be also told about any discharge from the mental health facility, and there are particular obligations on care providers around the information that is to be given to consumers and carers at that point in time, and I'll return to that in a moment. Fifth, you must be told if a decision is made for the consumer to be classified as a voluntary patient. Now, that can occur in a number of ways. Most commonly, care provider may come to the view that the person no longer needs to be detained on an involuntary basis and make that decision. Secondly, the tribunal has a power at hearings to also make the call that the person must remain in hospital as a voluntary patient and not an involuntary patient. Sixth, you must be advised of any application to the tribunal for particular medical treatments, ECT, short form for electroconvulsive therapy, surgery or special medical treatment. Now, these notifications that I've just referred to must be given to you as soon as the treating doctor is aware of these events. Finally, you must be advised of any proposed transfer to another mental health facility before it occurs, except in the case of an emergency. The second main way carers are involved with a consumer after admission to a mental health facility is when a person is brought to the facility, there is a requirement under the Act that they be assessed by 2 doctors, one of whom must be a psychiatrist, for them to consider whether or not the person should remain in hospital for a further period of time. Now, that first assessment should take place within 12 hours. If the person's found to be mentally ill or mentally disordered, then there must be a second assessment as soon as possible. Now, the doctors making that assessment are to consider any information that you have that is relevant to the decision to detain. Now, you may have observed behaviours which might assist in the doctor forming that view about the need for further involuntary care. Now, in the same way that doctors must consider information that you have at the point of admission, it's also the case when a decision is going to be made about whether or not a person should be discharged, that they must consider information that you have that is relevant to the decision as to whether or not the person should be discharged. For example, a person may be in a mental health facility for a period of time and they've been given some leave to stay with you at home, and that is often given, so treating teams can make a call as to whether or not it is appropriate to finally discharge the person. Now, you might observe behaviours or interactions which might suggest to you that discharge is not yet appropriate. Carers can also request information about medication. This can be either during the admission or if your loved one is on a community treatment order. What you can request is information about the type and dose of medication that is being currently given or has recently been given. Now, you should be aware that unless you have the permission of your loved one to access their private health information, not all information can be accessed. You can't access diagnosis, the treatment other than medication, the results of any tests or assessments, or the content of any conversations between care providers and consumers. That can only occur if permission is being given, and I'll come to how that might occur later on. The third way of being involved under the Mental Health Act is by being consulted about discharge and recovery planning. Now, the treating doctor is obliged to provide you with very specific information, and I'll go through these now. Mainly, you are to be given descriptions of follow-up care. For example, the Mental Health Act refers to you being advised about patient support groups, community care groups in the vicinity of the mental health services, mental health facility, including services provided by those groups and how to contact them. You are to be advised about any outpatient or other services available at the mental health facility that are available. The care provider must describe to you what a community treatment order is and advise you how you go about obtaining one. And you must be told of similar follow-up services that are in the vicinity of the mental health service. Care providers must also consult. There's an obligation on care providers to consult with agencies and services that are relevant to you, to the consumer, and to the dependents of consumers. This is a stage where you might wish to put forward your views as to what services or activities might promote your loved one's recovery. Carers must also be consulted before a community treatment order is revoked by a mental health facility. Consumers, directors of mental health services have a power to simply revoke an order without regard to the tribunal, but it must first advise you before the revocation of that order that it intends to do so. And of course that's to allow you an opportunity at that point in time to have some input into that decision. Care providers must also tell you if no further application for a community treatment order is going to be made. Also, you must be told if a community treatment order is going to be varied or revoked. If that occurs, there is a tribunal hearing generally, and you would have an opportunity to have input at that time. You should also know that carers have a right to request that your loved one be discharged into your care. For that to occur, you must give a written undertaking that you will take proper care of your loved one, and this may be approved by a care provider if he or she is satisfied that measures are taken to ensure their safety or the safety of members of the public. Now, if that request is refused, then you have a right to appeal to the tribunal to consider that request. The tribunal then has the power to consider your request, and if the requirements under the Act are met, order discharge. And as I alluded to earlier, you also have the right to apply for a community treatment order. Now, having said that, it's not straightforward. You would need the support of the mental health facility, that is the services, who would then need to provide a treatment plan, setting out the treatment and services for the consumer. But you should know that you are perfectly entitled to approach mental health facilities and make that request. The fourth method of carer involvement is in tribunal hearings. Now, I should just explain a little bit about tribunal hearings. They're not meant to be adversarial. It's not like a court, and the tribunal is very keen to hear from consumers and carers. The decisions of the tribunal are based on evidence and on legal criteria that is set out in the Mental Health Act. Now, a fundamental principle of the hearings is that consumers must be given a fair hearing, and they're entitled to be given notice that the hearing is going to take place. They're entitled to know what evidence is going to be put forward at the hearing, and be given an opportunity to be heard and to respond to matters that are raised at that hearing. Now, it's a guiding principle in the Mental Health Act that involuntary care should be the last resort, and that care and that treatment should be consistent with safe and effective care, and that consumers and carers should be involved and consulted. I can say to you, after many years of experience at the tribunal, I very much welcome the input of carers. It's often carers who know the consumer best and who can guide and assist the tribunal in the decisions that it makes. And whilst the tribunal must make decisions based on legal criteria, often a hearing is an opportunity to discuss a range of matters that touch on the well-being and welfare and recovery of the consumer. So that is a perfect opportunity, if you like, for you to have input into the services and the treatment that's being provided. The tribunal cannot tell treating teams what medication or treatment should be given, but we are bound to ensure that any treatment given is consistent with safe and effective care. And if you have insights into that, we welcome your input at the hearing. I should just also explain, and this is not often well understood, tribunal hearings are open to the public. Often they're very difficult to access, particularly if those hearings occur in a locked ward or at the prison. But sometimes it's not tenable for you as carers to attend a hearing because of the attitude of the consumer. It may be at the point of time that the consumer is admitted at the mental health facility, they don't want your involvement. And that is really quite common. You should know that the tribunal can be flexible in the way it hears from you. You can be available by telephone. If you have particular concerns, you can raise them with the care providers, and those concerns in turn can be communicated to the tribunal during the hearing. And the tribunal also has a flexible power to hear from you separately in particular circumstances if that is necessary. So I just want to leave you with some tips in terms of involving yourselves in the care of your loved ones. I think it's important that you establish early and ongoing contact with care providers. I think the squeaky wheel gets the oil, and so the continued expression of wanting to be involved and being consulted is really the very best way to get information and to provide important information. Another way is, of course, is to be nominated as a designated carer by your loved one. Now, that is best. There is an obligation on care providers when a person arrives at a mental health facility or is placed on a CTO to nominate their designated carer. Another way is when the consumer is well, is to try and have a document signed by the consumer indicating that the consumer gives you permission to access their private health information. That is a document that I think you can wave around to hospitals. I think I heard a cynical laugh. To indicate that you have your loved one's permission to be involved in their care. The tribunal respects and welcomes your involvement and the assistance you provide to consumers at the hearing, and I, for one, am very grateful for your involvement in the work that you do, and also on the occasions that you have been involved in tribunals. I know that it has often changed the complexion and the outcome of hearings. So thank you. Do you want me to? Okay.
Thank you, Mary. I'm going to do that all day. Maria, we've got a really big topic up front, as you can tell. I mean, fundamentally, the issues and the examples raised there were around power, access, respect, information. I particularly love that cynical laugh around waving the paper, because that's contingent on the care provider actually recognising your role and respecting you at a time of crisis, which, yeah, we know, we've been there. So what we were hoping to do, and I really do thank for that overview around systems, not just paperwork, but the actual systems, the mechanisms, whether that's a tribunal, whether it's a care provider. There are a couple of key things in there for me were, fundamentally, how do you as a carer get information? Not from your loved one, but from the people who have the authority or the power under the current system. The second one was, how do you insert yourself into that? Are there any ways that you can, either in preparation, get a document done, get approval from your loved one to access your records. There may be other ways that people in this room have actually found that have actually worked for you. That might be specific to your loved one, to their experience, to where you live, the quality of the care providers. So what we were hoping to do was get tables to spend about 15 minutes. That's it. We're giving you a taster first, okay? 15 minutes we're going to spend on the tables talking about the issues that were just raised. You all know the stories. If I asked each and every carer in this room to give me just one example, we would be here till about tomorrow. So we know the issues, okay? As John said in the opening as Commissioner, today is really trying to find out some tips, some strategies, some ways through this. Things that you as a carer have either worked out, found out, or that somebody's told you about. So in this 15 minutes, I want you to act as a bit of a brains trust. So imagine you are one of those support groups that was just mentioned, that you're supposed to be advised of. If somebody new came to your table, what would you tell them? They're brand new to this. They have a loved one who might be under a CTO. They have a loved one who may have discharge from a facility. What would you tell them? Given your knowledge, your experience, not in government speak, not in legalese, but in basic practical terms. And you've only got them here for 10 minutes because they've got to nick off and then care for their loved one. So try and use that focus. There are a couple of tables that have got a lot of people and a couple that have got some spare seats. My tip is, if you're at a table with lots of people, that means that you are going to get less time to talk. So if you can find a table that's only got 2 or 3 people, it's evening up the opportunities. And we'll move around during the day. So there's a couple of seats definitely clear over here, 3 over here, 3 seats over here, and a bunch of seats over here. Okay? This is John's got his table over here if you want to go with him. Now, I'm going to have to be fairly strict with timing. And part of the reason for that is we will also get questions from people. John mentioned Facebook, live streaming. So this is where I get to feel really old, because it's only my son and my nieces and nephews who just go, and they just do it. They love this stuff. But it's also a really safe way for many consumers and carers to actually put in a question safely. So we may get some questions off that live stream. If we do, I'll give you that feedback as well, incorporate that. So anybody on the live stream, please feel free to send that in and we will incorporate it.